Shortly before this matter was to be heard, however, a settlement was reached between the parties, pursuant to which the President issued the proclamation which brought into existence the present Commission. On the 4th of November 2011, the President established the present Commission to inquire into, make findings, report on, and make recommendations concerning the matters outlined in the terms of reference, which are set out hereunder and read as follows. 1.1, the rationale for the SDPP. 1.2, whether the arms and equipment acquired in terms of the SDPP are underutilized or not utilized at all. 1.3, whether job opportunities anticipated to flow from the SDPP have materialized at all. And 1.3.1, if they have, the extent to which they have materialized. And 1.3.2, if they have not, the steps that ought to be taken to realize them. 1.4, whether offsets anticipated to flow from the SDPP have materialized at all. And 1.4.1, if they have, the extent to which they have materialized. And 1.4.2, if they have not, the steps that ought to be taken to realize them. 1.5, whether any person or persons within and or outside the government of South Africa improperly influenced the award or conclusion of any of the contracts awarded and concluded in the SDPP procurement process. And if so, 1.5.1, whether legal proceedings should be instituted against such persons and the nature of such legal proceedings. And 1.5.2, whether in particular there is any basis to pursue such persons for the recovery of any losses that the state might have suffered as a result of their conduct. 1.6, whether any contract concluded pursuant to the SDPP procurement process is tainted by any fraud or corruption capable of proof, such as to justify its cancellation and the ramifications of such cancellation. The terms of reference define the scope of this commission and determine its ambit. Any matter falling outside the scope of the terms of reference has no relevance at all and should not be entertained. The terms of reference are a product of legislation, and the inquiry which this commission is mandated to carry out is determined by its terms. After all the evidence has been heard and before this inquiry terminates, the commissioners may call upon the team of evidence leaders, and indeed all the other legal teams present, to make submissions as to what the appropriate recommendations of this commission should be. Those submissions are determined by an analysis of the evidence presented to the commission and based upon facts and inferences arising from the evidence. It is at that point in time that it would be appropriate for the team of evidence leaders to submit what their views are on the evidence which has been led. At this stage, one can merely speculate as to what such findings would be. The evidence proposed to be adduced will be presented to the Commission in phases. The first phase deals with the following terms of reference. A, the rationale for the SDPP. B, utilization of the arms and equipment acquired. C, the flow of job opportunities from the SDPP. And D, offsets. During the first part of this phase, the various government departments, entities, and the Cabinet subcommittee which were involved in the acquisition of the SDPP will be called upon to deduce before the Commission evidence which will shed light on the issues listed above. These departments and entities include the Department of Defense and Military Veterans, the Armaments Corporation of South Africa, or Armscor as it is generally called, the Department of Trade and Industry, and the National Treasury. In this phase, evidence will be presented to this Commission setting out A, a history of the state of the forces as they were before the decision was taken to acquire armaments. B, the process followed by government to determine the needs of the defense force and its ability to discharge its constitutional mandate. C, the origins of the strategic defense procurement package. D, the reasons for the purchase of arms, that is the rationale. E, the cabinet decision to acquire arms. F, the procurement processes applicable at the time. In the second phase of the hearings, the Commission will hear evidence from those members of the public who have made written submissions to the Commission pursuant to the call for submissions issued by the Commission on the 9th of May 2012, and such other witnesses as may be subpoenaed. The second phase of the hearings, which will be scheduled after the 31st of January 2014, will deal inter alia with the evidence of the critiques which, for the large part, will be at variance with the evidence given by the functionaries of the executive in the first phase. Included amongst the persons due to give evidence in the second phase are Patricia DeLille, David Mania, Gavin Woods, Reinette Talliard, Henny van Vieren, Andrew Feinstein, Paul Holden, Terry Crawford Brown, and Richard Young. These critics will inter alia contend: A, that South Africa was not at the time when the SDPP was concluded faced with any short to medium-term military threats. B, that priorities such as housing, electricity, and job creation should have been the focus and delivery priorities of those who governed us. C, that the greatest threat to South Africa's security at the time was poverty and unemployment. D, that the arms and equipment acquired in terms of the SDPP are underutilized or not utilized at all. E, that the economic benefits to the country by way of offsets flowing from the SDPP process have not materialized to the extent contemplated at the time when the strategic defense procurement package was mooted. F, that this country could simply not afford the financial burden imposed upon the country by the strategic defense procurement package. As would be apparent from the analysis set out herein before, the first phase of the Commission therefore deals with the executive justification for the strategic defense procurement package, and the second phase deals inter alia with the attack by the critiques of this justification, whether these arms were in fact necessary, and whether the job opportunities and offsets contemplated had any real benefits for our country, whether such benefits had been overstated, and whether the true costs of the SDPP outweighed the limited benefits flowing therefrom. It is the interplay between the participants in that debate which will unfold during the first and second phase of the hearings. The scope of the second phase of the hearings is potentially much wider than the issues arising in the first phase. The witnesses who will be called will give evidence inter alia to the effect: A, that there were serious irregularities in the procurement process. B, that there were a number of individuals who influenced the outcome of the bid adjudication process. C, that the bid adjudication process may have been manipulated to ensure that contracts were awarded to specific bidders. D, that 3 of the 4 primary contracts forming part of the SDPP and at least 4 of the subcontracts had been subject to manipulations by officials overseeing the process. During this phase, the Commission will also deal with the question of whether any basis exists for the state to recover losses that may have been suffered resulting from the conduct of any person improperly influencing the conclusion of any contracts awarded in the SDPP procurement process. The Commission will also be seized of the issue as to whether the contracts concluded are tainted by fraud or corruption, such as to warrant the cancellation of these contracts and the ramifications of such cancellation. These aspects are relevant to paragraphs 1.5.1, 1.5.2, and 1.6 of the terms of reference. Whether the remedy of cancellation is available in relation to a particular contract will be a matter which will be carefully considered, as well as all other possible remedies available upon an analysis of all the evidence in this regard. During the second phase of the hearings, those persons who have been implicated of wrongdoing will also be given an opportunity to place their version before the Commission. It is not appropriate to release the names of the implicated persons at this stage. The Commission has considered it fit that before such persons or entities are named, they should have the benefit of a notice from the Commission informing them that they will be implicated by persons who have made submissions to the Commission. These notices to implicated persons will be given before the second phase of the hearings commence. Finally, and before I hand over to Mrs. Ramakaga, we wish to raise a few further matters. Firstly, we wish to urge those legal teams present here and those that will no doubt emerge in the future to assist the Commission in discharging its mandate effectively and efficiently. 14 years have elapsed since the Delil dossier was presented to Parliament. Any further extended period of delay impacts on the credibility of the Commission and may relegate to irrelevance its findings. The South African public is crying out for answers, and we would urge all legal teams to assist in making this process as smooth as possible and not to place unnecessary obstacles in the way. Finally, we wish to say that the Commission should not be judged on speculation, but on the results it achieves as it sets out to fulfill its task and when it finally completes its work. Give those who have been implicated the opportunity to demonstrate whether the finger of suspicion has been correctly placed at their door. Give us space to carry out the work which we are enjoined to do. The findings of the Commission have the potential to regenerate our nation and to give renewed faith in our people, in the validity of the legal processes, and in the rule of law. Give it the backing and support it deserves. And I call upon Mrs. Ramakaga to deal more specifically with matters to be raised in the first phase of the hearing. Thank you.
Thank you, Mr. Chairperson. Commissioners, officials of various government departments and entities in attendance, members of the public and the media. The opening address that I am going to present is the opening address that is done on behalf of all members of the evidence leading team. The evidence to be presented during this first phase will be limited to the terms of reference 1.1 to 1.4, which deal with the rationale, utilization, and the offsets, including jobs. The Commission intends to lead the evidence of government departments and entities in the first part of the first phase, and the evidence of witnesses who criticize the armament acquisition in the second part of the first phase. The summary of the evidence to be led is as follows. I'll start off with rationale introduction. The rationale for the Strategic Defense Procurement Package, commonly known as SDPPs, meaning the reason for the procurement, will mainly be outlined by the evidence led from the following departments and entities: the Department of Defense and Military Veterans, commonly known or referred to as the DOD, the Armaments Corporation of South Africa, commonly referred to as ARMSCO, and the National Treasury. Now, on utilization of equipment, evidence relating to the utilization and non-utilization of the equipment will be led by the DOD, mainly from the two arms of service, the South African Navy and the South African Air Force, as well as by the acquisition arm of the DOD, namely ARMSCO. realization of job opportunities from the SDPP and the offsets anticipated to flow therefrom. The evidence in respect thereof will be led mainly by the Department of Trade and Industry in relation to the National Industrial Participation, commonly referred to as NIP, and by AMSCO in respect of the Defense Industrial Participation, which is normally referred to as DIP. Now, regarding the criticism of the acquisition, the evidence of government departments and entities will be followed by evidence from interested parties that criticize the SDPPs. Such witnesses have been identified from their written submissions to the Commission and their written statements to the Commission. Further, the Commission may, by virtue of the powers vested in it, call such persons or entity as it deems necessary to testify. The common question among those who criticize the acquisition is, why did the country spend so much money on arms at a time when it faced no internal or external military threat, but when social needs of people were vast? The criticism includes issues pertaining to executive accountability, the acquisition impact on the macroeconomy of the country, procurement best practices, and allegations of impropriety on the part of decision makers in the acquisition. Now I tend to present the chronology of the presentation of the evidence. The Department of Defense and Military Veterans will be the first department to present evidence. The DOD will explain the determinants of the size and shape of the SANDF, the principles underpinning deterrence strategy, the characteristics of the primary defense posture of the South African National Defense Force, commonly referred to as the SANDF, and the functions, roles, and tasks of the SANDF. Further, the DOD will present evidence that it identified the following: the need to transform the SANDF, the need to equip the SANDF for new regional roles, the needs for long-term force design planning approach, and the need for a new force design. Having identified these needs of the SANDF, the DOD decided to undertake a comprehensive defense review. The review would entail comprehensive long-range planning on the transformation of the SANDF, including its armament capabilities. The defense review was undertaken parallel to the arms acquisition process, which had commenced after the adoption of the white paper. The two processes were spearheaded by the Joint Standing Committee on Defense. Subsequently, the DOD decided to rather opt for an arms package procurement rather than piecemeal acquisition. This ultimately led to the armament acquisition package, now commonly known as the SDPPs. The Joint Standing Committee on Defense was given the oversight function to assist the DOD's acquisition program. The evidence on rationale will deal with the following material issues: the history of arms acquisition prior to the SDPP process, the impact of the arms embargo on arms acquisition prior to the SDPP process, the defense budget reduction during 1990 to 1995, and the consequent effect on arms acquisition. The initiative from the Navy and the Air Force to procure military equipment prior to the SDPP process, the consultative process leading to the adoption of the defense review. which had been preceded by the White Paper. The adoption of the Defence Review by the National Assembly, the implementation process of the Defence Review, the audit of the internal process by DOD. I beg your pardon, I'll rephrase, or I'll rather repeat. The audit of the internal process of DOD by the Inspector General. The evidence on utilization will deal with the following material issues. Through the SDPP process, the DOD acquired the following equipment: 4 corvettes, 3 submarines, 30 light utility helicopters, referred to or described as Augusta A109, 24 lead-in fighter trainer aircraft, referred to as the Hawk, and 26 light fighter aircraft, referred to as the Gripen. The Navy and the Air Force will lead evidence on the utilization of the aforesaid equipment, which includes maintenance, training, and force preparation, as well as participation in the following: local, regional, and multinational exercises, peacekeeping missions, rescue missions, and patrols. Evidence will be laid on the following factors that impact on utilization: budget, defects, personnel, and maintenance. The next entity to present evidence will be the Armament Corporation of South Africa, which is referred to as AMSCO. The acquisition process. It will lead evidence on the acquisition process. AMSCO was the acquisition agency of the DOD, with its board serving as the State Tender Board. It will lead evidence on the acquisition process, which includes the following: applicable legislative and policy framework, processes followed and applied to cure any deficiencies in the existing and applicable policies and directives, establishment of various committees during the acquisition process, powers and functions of the said committees, management of the bid process up to and including recommendations to the designated ministerial subcommittee of cabinet, defense industrial participation programs, utilization of the equipment purchased to the extent necessary. The Department of Trade and Industry will lead evidence on job creation and offsets. The department was tasked with monitoring the offsets program. The evidence which will be laid will deal extensively with the mandate given to the DTI, the methodology of how credits were to be given on the various arms manufacturers or associated entities in terms of the National Industrial Participation Program and certain of the offsets projects. The DTI will give evidence in respect of inter alia the following: management and monitoring of offsets and the status of the offsets. The next entity that will lead evidence will be the National Treasury. It will lead evidence on the affordability of the SDPP and conclusion of the agreements. On the 18th day of November 1998, the Cabinet approved recommendation on the international offers and the preferred suppliers. Consequently, a negotiating team led by the chief negotiator and supported by the Department of Defense, including AMSCO, Trade and Industry, Public Enterprises and Finance, was mandated by Cabinet to negotiate an achievable funding arrangement and an affordable package with the preferred suppliers, which would result in final contracting for the offered equipment to the SANDF. The negotiating team constituted the International Offers Negotiating Team, which is commonly referred to as the IONT. The IONT performed its tasks within the terms of reference approved by the Ministerial Committee. Treasury convened the finance work group of the IONT and was led by a senior manager in the budget office, staffed by, among others, economists and advisors within and outside the department. The financing work group inter alia was expected to do an affordability or budgetary analysis and proposal, assessment of funding options and proposals for funding strategy, assessment and proposal regarding economic implications of the SDPPs. IONT submitted various reports to the Ministerial Committee in accordance with its terms of reference. In particular, the affordability team or finance work group of the IONT was instrumental in the compilation and presentation of the affordability of the Defense Strategic Armaments Packages report to the Ministers' Committee on the 31st day of August 1999. The report took into account the impact of the procurement on the fiscal, financial, and economic conditions. The affordability team made recommendations on its assessment of the SDPP economic, physical, and financial impacts. Loan facility agreements were negotiated and concluded between the Republic of South Africa and various foreign entities as part of the financing of the SDPP. The initial cost of the SDPP was indicated as approximately 29.9 billion rands. However, by October 2010, the cost of the SDPP was stated as approximately 42.3 billion rands. The final capital payment was due in April 2011, and an amount of 4.9 billion was estimated to have been paid by then. The report estimates that the finance charges on the capital amount of the SDPP will be settled by 2018, noting that the contracts concluded require payment in foreign currency, exchange rate fluctuations has and will inevitably affect the cost incurred in the purchase of the SDPP equipment. Subsequent to the conclusion of the loan facility agreements, Treasury continued to monitor and manage the liability arising from these loans. Treasury will thus lead evidence on the role it played regarding the matters above and any other matter incidental thereto with reference to the following: budget, the price and incidental matters thereto, the affordability of the SDPP, financing of the SDPP, SDPP loan agreements, and liability management thereof. The subcommittee of Cabinet, which is commonly referred to as the Ministerial Committee, will present evidence on the final acquisition and the implementation of the Cabinet decision. The Commission intends to inquire into and investigate the process followed by the Subcommittee of Cabinet, which was constituted by the then Deputy President as chairperson, the Ministers of Defense, of Trade and Industry, of Finance, and of Public Enterprise, in relation to the appointment of the preferred bidders and the overall affordability of the SDPP and matters connected thereto. The Ministerial Committee convened meetings to consider the recommendations made to it relating to the preferred suppliers of the SDPP, the progress report on the terms of reference of the International Offers Negotiating Team, that is the IONT, relating to inter alia, non-defense industrial participation, that is the NIPS, defense industrial participation, that is the DIPS, the affordability of the SDPP, the technical aspects and financing of the SDPP. Evidence from the Ministerial Committee will be in respect of the following: executive accountability, appointment by cabinet, powers and functions, execution of mandate, processes and deficiencies, interaction with the project teams, recommendations to the cabinet. Part of this phase, people that criticize the SDPPs will lead evidence. The announcement of the decision to procure the armament and the subsequent procurement drew a lot of criticism from different individuals and interest groups, including the chairperson of SCOPA and some members of SCOPA. On the 9th day of May 2012, by way of government notice, the Commission invited interested parties to make written submissions on affidavit in respect of all or specific terms of reference. The following persons or entities accordingly made submissions: Sean Bozalek, Kerry Crawford Brown, Paul Holden, Patricia DeLille, BA East Systems PLC, David Mania, Andrew Feinstein, who will later be referred to as Feinstein, and the Ceasefire Campaign. In the exercise of its discretion in terms of Clause 4 of the government notice dated the 9th of May 2012, the Commission will, on notice, require some of the interested parties who have made submissions to make oral representations during the public hearings. This part 2 of this phase of the public hearings, the Commission intends calling the following persons who criticize the SDPP acquisition for one reason or the other. And those persons are Patricia DeLille, David Mania, Paul Holding, and the following from SCOPA: Gavin Woods, who will later be referred to as Woods, Feinstein, and Renette Talliard, who will later be referred to as Talliard. The respective persons will be required to give evidence on issues raised in their submissions, whose brief synopsis is as follows. Firstly, SCOPA. Evidence from the then chairperson and some members of SCOPA will be led on matters arising from inter alia the following: the AG's report tabled on the 15th day of September 2000 before Parliament, the President's refusal to issue a proclamation authorizing and empowering the Heath Special Investigation Unit to participate in the investigations, various interventions on the part of respective government and parliamentary role players and agencies concerning the joint investigations and the role of SCOPA. In particular, Feinstein and Talliard have written extensively on these concerns in their books titled After the Party and Up in Arms, respectively. The chairperson of SCOPA resigned on 25th February 2002. the decision to resign was informed by the chairperson's view that SCOPA was undermined by political interventions and that the joint investigation team failed to conduct a proper investigation. Now, I tend to give further synopsis of the individual critics. Terry Crawford Brown's evidence will deal in particular with the offset program, the difficulties encompassed in it, and whether offset programs have worked worldwide. He will also deal with whether the relevant government ministers exceeded their authority by signing the strategic defense procurement packages contracts. Paul Holden and Andrew Feinstein have jointly made written submissions under oath to the Commission, and they have affirmed that they are willing to testify in person before the Commission. They criticize the SDPP on the following basis. 1, irrationality of the arms deal. They believe that the decision to pursue the SDPP acquisition was fundamentally irrational, considering South Africa's post-apartheid military posture and the country's overwhelming socio-economic needs. 2, job creation and macroeconomic considerations. They submit that the SDPP failed to create 65,000 jobs that were promised when the planned acquisition was announced in December 1999. They further submit that it is apparent that the procurement team in charge of the acquisition, including the cabinet subcommittee in charge of the procurement, were made aware that the SDPP was, in the best case scenario, likely to produce either neutral or negative job figures. 3, offsets. The evaluation framework of offsets. The criticism pertains to how the offset credits were awarded and how the multipliers could have the effect of undermining the envisaged real value of the offsets. Offsets in fulfillment in the South African arms procurement. Key to this issue is the calculation and assessment of the performance of the offsets. The appropriateness of offsets. A research conducted on the offsets program suggests that a number of projects have either terminated due to failure or criminal misdemeanor. Irregularities in the selection process and allegations of corruption. They submit that they believe that the selections of 3 of the 4 primary contractors in the SDPPs were done in an irregular manner. They state that there were gross procedural irregularities that impact on the selection of the preferred contractors for the Alpha/lift components, the submarines, and the corvette contracts. Now I tend to give the summary of Patricia de Lille. Patricia de Lille's evidence will deal mainly with the fact that she reported suspected impropriety around the SDPPs to Parliament in September 1999 and requested that the acquisition be probed. She handed over the documents to former Judge Willem Heath. However, the Special Investigating Unit required a proclamation from the President, and the President did not issue the proclamation empowering the unit to investigate. The NPA retrieved the documents from Judge Heath. Subsequently, she received death threats and was made to appear before the investigating directorate, Serious Economic Offences, that is the DSO commonly known as the Scorpions. With no progress forthcoming on the investigation, she requested for a nolle prosequi certificate so that she could institute private prosecutions. David Mania's testimony will focus on the offsets projects that have partially or not materialized at all, the utilization or lack thereof of the capabilities acquired for the Defence Force, and the number of jobs that have materialized from the SDPPs. He will also give testimony in relation to item 1.5 of the terms of reference. As already stated, the DOD evidence will be led mainly by witnesses from the Navy and the Air Force. The first three witnesses to testify are Admirals Green, Hicks, and Schultz, in that order, from the Navy. Admiral Green will shed light on the mandate of the SANDF, its functions, implementation of policies, which culminated in the decision to purchase the armaments which are the subject of this inquiry, the defense strategic objectives, and will give a broad overview of the rationale of the SDPP and the utilization for the SDPP. I beg your pardon? I think I've made a mistake. Utilization for the SDPP. Detail will be provided by the members of the various arms of service. Lastly, he will focus on the funding profile of the acquisition of assets. Admiral Hicks will give evidence mainly on the following: the purpose of the defense review, its rollout, as well as its approval by Parliament. The establishment of Project Optimum, its role and how the project was undertaken. Project Optimum is a project that was established to help determine the force design of the SANDF in an environment with no clearly defined threats. Admiral Schultz will give evidence mainly on the naval capability deficiency history, dating as far back as 1975, and interventions that were put in place in an attempt to cure those deficiencies. The utilization of the frigates and the submarines. The areas to be covered by each witness will progressively be given in advance during the hearings and on the Commission website. The Commission would like to bring to the public and interested parties the procedure that will be followed during the public hearings. And that procedure is as follows. The conduct of the procedures of the inquiry shall be conducted under the control and discretion of the chairperson. The Commission shall determine whether the evidence presented to the inquiry or a representation to the inquiry is to be in writing or oral. Any person appearing before the Commission may be assisted by an advocate or an attorney at own cost. No person appearing before the Commission may refuse to answer any question on any ground other than the privilege contemplated in Section 3, subsection 4 of the Commissions Act. No evidence regarding questions and answers contemplated in Regulation 8, subsection 1 of the regulations, and no evidence regarding any fact of information that comes to light in consequence of any such questions or answers shall be admissible in any criminal proceedings, except in criminal proceedings where the person concerned is charged with an offense in terms of Section 6 of the Commissions Act or Regulation 14. Any witness appearing before the Commission may be cross-examined only if the chairperson permits such cross-examination by such person because the chairperson deems it necessary in the interest of the functions of the Commission. Any person may be re-examined by his or her legal representative for the purpose of explaining the evidence given by the witness during his or her testimony. The hearings of the Commission will be public. However, with leave of the chairperson, the proceedings may be held in camera in terms of Section 4 of the Commissions Act. Where at the time of any person presenting information to or giving evidence before the Commission, members of the general public have been excluded from attendance at the proceedings of the Commission, the chairperson may, at the request of such person, direct that no person shall disclose in any manner whatsoever the name or address of such person or any information likely to reveal his or her identity. That concludes this opening address. Chairperson, Commissioners, I thank you.
I see it's 11:30 now. I'm sure there will be no objection if the conference is brought forward to 12 o'clock. If at all there are any objections, I'm sure you can deal with those objections at 12 o'clock when you meet. Otherwise, we'll meet you tomorrow morning and we'll start at 9:30. Thank you.